Assalamu alaikum. How are you all doing? Firstly, I've been told there's over 100 delegates, 100 different countries here. So firstly, I want to say welcome to my campus. It's a real pleasure to be speaking here, not listening to a lecture and taking notes on the opposite side. So a real pleasure. Just want to contextualize myself in this conversation as I'm a British Somali activist working in the intersection of climate justice, education and migration. And as you've heard, I co-founded Students Organising Sustainability, which is an organisation that launched the Climate Education Bill, which was written by young people, which pushed education as a right, not as an additional add-on, climate literacy as a right. I, as you heard, served as the president of the National Union of Students in the UK, as the vice president of the European Students' Union, and today I share the Muslim Leadership Foundation, and also I'm a director of an organisation called the Somalis for Sustainability, and I'm also a youth advisor to the UN Green Jobs Pact. I'm not telling you this because anyone's interested in my resume, but I do want to bring in and explain my vantage point here and why I come to this conversation. I'm not a lawyer, and I don't work inside international legal negotiations, alhamdulillah. But my work sits with the people who live on the consequences of those very systems. From training young people in campaigning and activism to drafting policy with agencies and ministries, a core part of what I do is making UNFCCC processes and climate agreements digestible for our communities. And like most environmental governance regimes, I'm expected to explain those systems, and I'm pretty sure most of us who engage with UNFCCC still don't really understand how it works or operates. But through Somali Sustainability, my work sits with Somalis and other diasporic communities navigating climate collapse, displacement, and political erasure. And I work alongside youth communities, organisers around climate negotiations and inside the drafting rooms. But in my time in this work, what I've learned is this. For many communities, international law is not abstract. It's in fact very, very intimate. It shows up in who gets funded and who doesn't, who is displaced and who is protected, and who's allowed to move and who's told to endure. And when we say international law is on trial, I want to be honest about something. The most vulnerable communities have been testifying for decades, but the courts just hasn't been listening. We're told that we're living through a moment of unprecedented erosion. States are withdrawing from treaties, human rights frameworks are under attack, and international judges and prosecutors are sanctioned for doing their very jobs. But from where I stand, this is not a collapse of a system that has ever worked. It is an exposure of a system that was always conditional. International law has long been violated by powerful states. We know this, there's many examples. The difference is not that they're breaking the rules. The difference now is that they're no longer bothering to pretend that the rules even apply to them. And that should alarm us. Not because the law was neutral or fair, but because even the performance of accountability is being abandoned. And that is worrying. And when the law loses its performative power, the people who suffer first are not the states. They're the communities without leverage. And nowhere is this clearer than the climate negotiations. COPs are framed as a site of multilateral cooperation, but the least developed countries are also sites of extraction. Countries arrive already in crisis to those spaces, facing climate disasters that they did not cause, burdened by debt, and structurally dependent on finance controlled somewhere else, often Switzerland, different conversation. And then they're asked to negotiate. They're asked to water down the language that they use, delay timelines, reframe justice ambitions, and accept voluntary mechanisms instead of binding obligations. So let's be honest about this. When countries' access to climate finance depends on how constructive it is in the negotiations, when survival is contingent on political compliance, and when speaking plainly risks losing funding, this isn't diplomacy, this is coercion. International law tells us that these negotiations are consensual. But consent extracted under existential threat is not consent, it's a survival bargaining. And we talk about these just transitions as if justice will arrive automatically, eventually, somehow. If we manage the process, got a little music going there, We talk about justice. We talk about just transition as if justice will arrive automatically and eventually, and if we manage the process well enough. But justice delayed is not neutral. It is violence. For many communities, a transition being offered looks like this: phase out fossil fuels without guaranteed of their livelihoods. Let's expand renewables without addressing the land theft. Let's promote resilience while refusing reparations. Let's celebrate adaptation while normalizing loss. This is not just transition. This is a reallocation of harm. And international legal frameworks often legitimize these priorities. Investor protections over people, trade law over climate law, and state sovereignty over human survival. When international law refuses to confront historical responsibility, it quietly endorses ongoing extraction. International law insists on neutrality, but neutrality is an unequal world in a world that's not innocent. It's just ideological. It freezes injustice in a place, and it calls it balance. And when law treats unequal states as formally equal actors, it erases colonial histories. When it separates climate harm from responsibility, it absolves polluters. When it frames displacement as a humanitarian issue rather than a political failure, it individualizes structural violence. The law does not simply fail to protect the vulnerable, it often disciplines them. By narrowing what they're allowed to demand, we talk about vulnerable communities as if their vulnerability is natural. It isn't. It isn't naturally caused. Vulnerability is produced by extraction, by borders, by debt, by racialized hierarchies of worth. The communities I work with are not powerless. They're far from it. But they're overexposed and underprotected. They have knowledge, they have strategies, and they have been adapting for generations. What they lack is an international system willing to constrain power on their behalf. And so whether we're asking whether the post-World War II legal order is unraveling, but perhaps a more uncomfortable truth is, it's unraveling because it no longer serves the illusion of fairness. If international law only functions when powerful states feel like they can invest, then it was never a safeguard, it was merely a convenience. The question is not whether we can return to some golden age of multilateralism. For many communities will argue that never really existed. The question is whether we're willing to imagine and fight for something that's far more honest, something rooted in justice. If safeguarding international law means preserving structures that manage injustice rather than dismantle it, then safeguarding it is not enough. When vulnerable communities are demanding is not better language or more inclusive panels or another decade of ambition, anyone that works in the UNFCCC will kind of know the ambition joke. They're demanding enforceable justice. They're demanding redistribution, not charity. They're demanding transitions that do not require sacrifice zones. They're demanding a legal order that treats survival as non-negotiable. So international law is on trial, but the verdict will not be delivered in courtrooms. It will be delivered in flooded villages, its displaced families, their future foreclosed by delay. And if the law cannot protect life, then the communities will not continue to organize beyond it, not because we reject the law, but because they refuse to die waiting for it to catch up. Thank you.